Good morning. Trust you all had a restful night. Welcome back. We have a beautiful day ahead. The last time we talked about the clauses in the time charter party, and we started with the hire clause, the duration of charter, delivery and redelivery clauses, the lay-current, that is delay days and cancelling, the off-hire clause, the bunkers, maintenance and running expenses, the employment of vessel. So today we shall continue from there. We also have the cancellation clause. So like a recap, let me explain the employment of vessel and cancellation clause, and then we'll continue from the war risk clause, the insurance clause, the law and arbitration clause, and the likes. The employment of vessel. This defines the purpose for which the vessel will be employed during the charter period. This could include specific trade routes, the types of cargo, or any other restrictions on the use of the vessel. It clearly outlines, defines, describes the purpose, the main function, the reason behind utilization of a definite vessel during a definite charter period. And he went further to say that it could be specific trade routes, the types of cargo, or any other restrictions on the exact utilization of a definite vessel. The cancellation clause. This clearly specifies the conditions under which either party can cancel the charter, including any penalties, notice periods, or compensation. For a clause called cancellation to come in, it means there are certain conditions that must be met under which cancellation can come in or set in. Now, for any cancellation to come in, should any cancellation involve, there are penalties involved. Either the ship owner or the charterer. If it is the ship owner that cancels the clause, which is against the terms and conditions, the ship owner will definitely pay a compensation or a penalty. And if it is otherwise, on the part of the charterer, a penalty will be made. Notice periods. Should any notice period set in and is not taken absolute cognizance of by either party, compensation or penalty will then set in. This is simple and straightforward. The next one is war risk clause. This addresses the allocation of risks and costs associated with war, civil unrest, pandemonium, great uproar here and there, or similar events that may affect the vessel's operation during the charter period. This clause is highly necessary because it may crop up, and once this crop up, it will definitely affect the modus operandi, the vessel's operation, during which the utilization of the vessel by the charterer involved. We don't pray for war, or should any civil unrest, tyranny, and oppression come in, it will definitely affect the ongoing operations of the vessel in use. Next is insurance clause. This specifies the insurance requirements for the vessel during the charter period. It may detail the types of insurance coverage required and the party responsible for obtaining and maintaining the insurance. This describes or specifies or identifies the insurance requirements. What are the things that will be needed for the vessel during the charter period? The type of insurance cover. The type of insurance cover while in use for a definite vessel. It may detail the types of insurance coverage, the type of risk, and the party responsible for obtaining and maintaining the insurance. Will it be the ship owner or the charterer, or a combination of both parties? This is simple and straightforward. We have the law and arbitration clause. Law and arbitration clause. This specifies the governing law and the mechanism for resolving disputes, often through arbitration. This clause establishes the legal framework for interpreting and enforcing the terms of the charter party. It specifies the governing law in use and the mechanism, the modalities involved for resolving disputes, should any crop up. Here it establishes the legal framework, the ways, the terms, the adoptions for the interpretation and implementation of the terms of the charter party. These clauses, among others, collectively form the contractual framework for a time charter party. The specific terms and conditions can be customized based on the needs and negotiations of the ship owner and the charterer. Legal professionals and maritime experts often play a crucial role in drafting, reviewing, and negotiating the terms of a time charter party to ensure clarity and fairness for both parties. Essentially, what it's talking about is that these clauses mentioned and explained earlier collectively form the contractual framework, the terms and conditions, the do's and don'ts, what binds both parties together, especially for a time charter party. And it went further to explain that legal professionals and maritime experts often play a crucial role. Of course, the legal professionals and maritime experts are involved in drafting, reviewing from time to time, and negotiating the terms of a time charter party to ensure clarity. The words used are not ambiguous. They have to be crystal clear for easy assimilation and understanding for both parties, the ship owner, the charterer. Certainly, here is an expanded list of clauses commonly found in a time charter party. One, we have the hire clause. We have the duration of charter. We have delivery and redelivery clauses. We have the lacron, that is delay days and cancelling. We have the off hire clause. We have the bunkers clause, maintenance and running expenses, employment of vessel, cancellation clause, war risk insurance, law and arbitration, fee and I club clause, that is the protection and indemnity. We have the lien clause, force majeure clause, inspection and survey clause, the ballast bonus clause, the zero compass clause. We shall take them one after the other. One, we have the hire clause. The hire clause. This specifies the rate at which the charterer will pay hire, the HIRE, for the use of the vessel. It may detail the frequency of payments and any adjustments based on performance or operational parameters. The hire clause. We are told here that it specifies the rate at which the charterer will pay hire for the use of the vessel. It specifies, it describes the rate at which the charterer will pay the ship owner for making use of a definite vessel. Indirectly, the charterer is hiring a vessel. And under this, it may detail the frequency of payments. Will it be in installments? Will there be any adjustments based on performance or in the cost of operations? The parameters involved, the variables. The duration of charter. This clearly defines the period for which the vessel is chartered. This could include the start and end dates, the renewal options, or provisions for early termination. Duration means the period within which a definite vessel is in use. Duration of charter. It specifies the period within which a definite vessel is in use as agreed by both parties. This could include the start and end dates, of course. It includes the start. When will the vessel be made use of? From what date? What is the starting date? And what is the end date? Okay, will it be done from the 1st of March to the 15th of March? From the 1st of March to the 30th or 31st of March, or beyond that? The months, the weeks, or days? The renewal options, should that period lapse? The period within which the vessel is in use, should the period lapse or come to an end, the renewal options where possible. This can be renewed. All provisions for early termination. This is embedded within the duration of charter in the MOU by both parties involved. Should there be any termination for which the use of a definite vessel has been fully employed, has been fully utilized? This can also be discussed, be identified in the duration of charter clause revolving around the terms and conditions. We have the delivery and redelivery clauses. This outlines the specific requirements and procedures for delivering the vessel to the charterer at the beginning of the charter period and redelivering it to the ship owner at the end of the charter. What delivery means is it specifies, it lays down the definite specific requirements and the procedures for delivering a vessel to the charterer at the beginning, at the start of the charter period. And having done the needful, having fully utilized the vessel, redelivery sets in. And this is done to the ship owner at the end of the charter. We have the lay days and cancelling. It specifies the period within which or during which the charterer can nominate the vessel for loading or discharging operations. The lay days are the specific days within the laycan during which loading or discharging must commence. Here, cancelling date sets the deadline for cancelling the charter if the vessel is not nominated within the lay can. Delay days and cancelling. It outlines, it specifies, it describes the days, the period, the duration, the era within which a charterer can nominate a definite vessel, either for loading or discharging in its operations. And where cancelling sets in, the dates must be set as a deadline for cancellation if the vessel is not nominated within the lay can. The off-hire clause. It describes the circumstances under which the vessel may be declared off-hire, relieving the charterer of the obligation to pay hire, H-I-R-E. Common off-hire events include dry docking, repairs, or incidents preventing the vessel's use. It describes the circumstances, the contingencies, the situations, the conditions under which the vessel may be declared on fire, relieving the charterer of the obligation to pay. The common events under this clause can be repairs, whilst the vessel is in use. Should anything crop up during discharge or loading, or while the vessel is in use on the sea, that may prevent the use of the vessel, the charterer then raise an alarm. In this instance, as such, the vessel may be declared off hire. The bunkers. This explains the party that is responsible for providing and paying for food. The charterer, in most cases, bears the cost of food. It also specifies the quantity and quality of bunkers at start and end of the charter period. The maintenance and running expenses. It allocates responsibilities for routine maintenance, repairs, and other running expenses during the charter period. The charterer is often responsible for day-to-day operational expenses. The maintenance and running costs. The maintenance and running costs are expenses, which may involve repairs, routine checks, routine maintenance, day-to-day operational expenses, which may be identified or not disclosed, and other running expenses during the charter period. Next is employment of vessel. This defines the purpose for which the vessel will be employed during the charter period. This could include specific trade routes, the types of cargo, or any other restrictions on the use of the vessel. Employment of vessel defines the purpose for which the vessel will be employed during the charter period. Cancellation clause specifies the conditions under which either party can cancel the charter. including any penalties, notice periods, or compensation. Again, cancellation specifies the conditions under which either party can cancel the charter, including any penalties, notice periods, or compensation. Whoever cancels the clause, whoever cancels the charter, he or she knows the penalties or compensation is set in. Next is war risk clause. This addresses the allocation of risks and costs associated with war, civil unrest, or similar events that may affect the vessel's operation during the charter period. This has been explained earlier. The insurance clause. This specifies the insurance requirement for the vessel during the charter period. It may detail the types of insurance coverage required and the party responsible for obtaining and maintaining the insurance. Law and arbitration clause. This clearly specifies the governing law and mechanism for resolving disputes, often through arbitration. This clause establishes the legal framework for interpreting and enforcing the terms of the charter party. The P&I Club clause. This is called the Protection and Indemnity Club clause. It specifies the protection. How do we protect and indemnify the ship owner or the charterer should there be any form of claim as to when compensation may set in? It specifies the protection and indemnity club to which the ship owner belongs. It may detail the responsibilities of the charterer in case of claims covered by the P&I club. This is a form of insurance. It specifies the protection and indemnity. Should there be any form of claim by the charterer to the ship owner where they both belong, in the course of transacting business, in the course of making use of the vessel, should there be any form of casualty whilst making use of the vessel, the charterer can seek a claim covered by the P&I club. We have the lien clause. The lien clause defines the circumstances under which the ship owner may exercise a lien on the cargo or other assets of the charterer to secure payment or performance of obligations. This means a situation whereby the charterer refuses to pay or complete a definite frequency of payment. The lien clause then sets in. The ship owner may decide to exercise a lien on the cargo or other assets as may be owned by the charterer to secure payment or performance of obligations. We have the force majeure clause. This addresses some foreseeable events or circumstances that may prevent either party from fulfilling its obligations under the charter party. There are some contingencies, there are some circumstances beyond our control. Quite alright. This clause, force majeure, this seeks to address the unforeseeable events that may crop up, such that it prevents or may prevent either party, either the charterer or the ship owner, from fulfilling its obligations under this exact charter party. The inspection and survey clause. The inspection and survey clause. This outlines procedures for vessel inspections and surveys, including who bears the costs and the frequency of such inspections. It outlines the procedures. For vessel inspections and surveys, for a vessel to be made use of or fully utilized, there comes an inspection by the inspection and survey team. You check, you survey, is it in good use? Is it in good form? Is it in good shape? Or does it need or requires any repairs? Including those who bear the cost and the frequency of such inspections. Should it require inspection from time to time, every 2 weeks, 1 month, or immediately after use, or whilst in use? The inspection and survey clause talks about this paraphernalia. You have the ballast bonus clause, which specifies the conditions under which the charterer may pay a bonus to the ship owner for ballasting the vessel to a certain location other than the agreed location. This is simple and straightforward. We have the gyro compass clause. This outlines the obligations related to the proper functioning and maintenance of the gyro compass on the vessel. It outlines the obligations, the duties related to the proper functioning purpose, and maintenance of the gyro compass on the vessel. These clauses collectively form the contractual framework for a time charter party, and their specific details can be customized based on the needs, preferences, and negotiations of the ship owner and the charterer. Legal professionals and maritime experts often play a crucial role in drafting, reviewing, and negotiating the terms of a time charter party to ensure clarity and fairness for both parties. We now move on to the demise charter party. The demise charter party. A demise charter party, also known as a bareboat charter, is a contractual agreement in the shipping industry where a ship owner leases a vessel to a charterer to make use of under terms that grant the charterer almost complete control and responsibility for the vessel. It allows the charterer, under the terms, to make use of a definite vessel, having almost complete control and responsibility for the vessel. And in a demise charter party, the charterer operates the vessel as if they were the owner, taking over crewing, maintenance, and other operational aspects during the charter period. This type of charter is distinct from both time charter parties and voyage charter parties. It allows the charterer to have complete dominance, control, and responsibility for the vessel. The charterer operates the vessel as if they were the owner, taking over the maintenance, crewing, and other operational aspects during the charter period. We also have some key features, attributes, characteristics, elements, and components of a demise charter party. Key features or characteristics or components of a demise charter party. Okay, the key features or components of a demise charter party. We have the vessel handover. We also have what is called operational control. We have the duration of charter. We have maintenance and repairs. We have insurance. You have the bareboat nature. You have the subcharging. You have the redelivery. You have the purchase option. You have default and termination. These are some of the key features, attributes, characteristics, or components of a demise charter party. They constitute some of the clauses that should a demise charter party involve. These are the parameters, these are the variables. These are the paraphernalia involved towards ensuring that we don't go outside the memorandum of understanding of a demise charter party, should such crop up. We shall explain them one after the other. We have the vessel handover. The ship owner delivers possession of the vessel to the charterer in a manner similar to selling the vessel. The charterer effectively becomes the disponent owner for the duration of the charter. The ship owner delivers possession of the vessel to the charterer for him to make use of, which is similar to selling the vessel. Indirectly, the charterer effectively becomes the disponent owner for the duration of the charter, and it's the period of which the vessel will be made use of by the charterer. When next we meet, we shall continue with other functions, other key components under the demise charter party. Thank you for listening.